that is going to be introduced to you in a minute by Advocate General Spooner is the so-called Cofemel judgment, a ruling on intellectual property law adopted by the Third Chamber of the Court of Justice of the European Union on 12 September 2019. This ruling is important for at least two reasons. First, it gives important clarifications on the EU legal definition of a work protected by copyright. Secondly, it confirms that if an object can be protected by different intellectual property rights, copyright and design in the case at hand, each right has its own conditions of application and scope of protection. It is my pleasure to introduce you to Mr. Spooner, who was the Advocate General in this case, Cofemel case. Born in Krakow, in Poland, Advocate General Spooner obtained a master's degree in law from the University of Silesia in 1995 and from the College of Europe in Bruges in 1996. He became a professor of law in 2013 at University of Silesia in Katowice. In 2001, he joined the bar to take up the profession of lawyer, a profession which he practiced until 2008. He was Under-Secretary of State in the Office of the Committee for European Integration in Poland from 2008 to 2009, before joining the Polish Ministry of Foreign Affairs from 2010 to 2013. During those 3 years, he represented the Polish government as an agent in many cases before the courts of the European Union. Mr. Spooner is also a member of the Board of Trustees of the Academy of European Law, and together with other high-profile representatives of this board, he advises the Academy of European Law, particularly about the planning of the program of events. Mr. Spooner was appointed as an Advocate General at the Court of Justice of the European Union in October 2013 and has held the position of First Advocate General since 11 October 2018. In his position, he has delivered a multitude of opinions in important cases that have contributed to shape the interpretation of European law, particularly but not exclusively in fields involving emerging technologies, online platforms, and complex technological issues. And now let's hear what Mr. Spooner has to say about the Cofemel case.
The legal protection of works of applied art is virtually as old as the legal protection of intellectual property in general. However, it still struggles to find its place within the system of intellectual property. This system covers three main areas. First of all, protecting inventions through patent law. Secondly, protecting intellectual creations through copyright. And thirdly, protecting reputation through trademark law. On account of the decorative and practical character and artistic and industrial purpose, works of applied art lend themselves to those three forms of protection without, however, perfectly satisfying the objectives or mechanism of any of them. The sui generis protection has been developed, in particular in Europe, but that protection has never become fully exclusive. It can still be combined with other forms of protection. The case Cofemel concerned the combination of protection of design under the sui generis regime and the protection of applied art under copyright law. The relationship between those two protection regimes has always been a source of indecision, both on the part of the legislature and in the case law, and it was linked with many controversies. On the other hand, the functional and practical character of works of applied art and the fact that they are designed to be mass-produced raise doubts as to whether they may be properly protected by copyright and whether that protection is consistent with its axiological foundations, like the personal link between the author and his or her work, and also with the objectives, which is the remuneration for the intellectual and creative effort involved. In particular, there are two dangers inherent in the copyright protection of works of applied art. First, overextension of the scope of copyright protection, and secondly, restriction on economic competition. For that reason, many legal systems have developed rules to ensure that copyright protection is limited to works of applied art only of high artistic value. But on the other hand, it is common ground that some works of applied art have a high degree of originality. One only needs to consider the styles developed in the areas such as Art Deco or Bauhaus. The same is true in the sector of activity at issue in the case of Cofemel, clothing, in which pieces of haute couture are more akin to works of art than items of clothing. It is not therefore justified to exclude a priori works of applied art from the scope of copyright protection on the sole basis that they have equally functional character. In addition, other categories of works which undoubtedly fall within the scope of copyright protection may also have a practical purpose, while at the same time being original intellectual creations. That is true of some literary works, like in the case of Infopack, where the 11 words could have been considered as a work within the meaning of copyright, photographic or even musical works. The Berne Convention, the main source of international law in the area, permits the parties to the convention to grant to individual designs and models a specific protection which may differ from and which may exclude the protection afforded to literary and artistic works falling within the scope of that convention, and to determine the conditions governing such protection. At the same time, that provision of Berne Convention does not rule out those two forms of protection being cumulative. On the EU level, we have in the first place Article 17 of Directive 98/71, which provides for the protection of designs, and this provision was confirmed in Article 96, paragraph 2 of the Council Regulation 6/2002 on community design. As far as EU copyright law is concerned, Article 2.1 of so-called InfoSoc Directive, Directive 2001/29, harmonize certain aspects of copyright, but its main provision says the member state shall provide for the exclusive right to authorize or prohibit direct or indirect, temporary or permanent reproduction by any means and in any form, in whole or in part, for authors of their works. So we have on the one hand provisions on design, and on the other hand harmonized EU law legislation on copyright done by the so-called InfoSoc Directive. What was the Cofemel case about? It was in 2013, the clothing company G-Star accused the fashion label Cofemel of infringing their right in respect of several items of clothing. In particular, G-Star argued that their RNC and Rhodey jeans and certain t-shirt designs were original intellectual creation and therefore constituted works that were entitled to copyright protection. Cofemel argued the opposite, that the items of clothing did not qualify as works and should not be protected by copyright. The Portuguese Court of First Instance agreed with G-Stars and ordered Cofemel to stop infringing its copyright and to pay damages. The Court of Appeal confirmed this decision. The case then made its way to the Portuguese Supreme Court, which considered that the clothing in question was the result of innovative concepts and manufacturing process containing a number of specific elements, and that Cofemel used some of these in the manufacture of their clothing. However, the Supreme Court decided that the Portuguese law does not specify the degree of originality that is required for these types of works to qualify for protection. Therefore, the Supreme Court of Portugal made a referral to the Court of Justice on the interpretation of Article 2.1 of the InfoSoc Directive, asking whether EU law precludes national laws from giving copyright protection to design works which generate a significant aesthetic effect on the basis of any other criteria apart from originality. Hearing on appeal brought by Cofemel, the Supreme Court of Portugal considered the following facts to be established. First, the items of G-Star's clothing copied by Cofemel were designed either by designers employed by G-Star or by designers acting on its behalf, who had assigned to G-Star the copyright to the design. Secondly, those items of clothing were the result of designs and a manufacturing process recognized as being innovative within the world of fashion. And third, those items were characterized by a number of specific elements: 3D effects, the positioning of various components, how they were assembled, and the combination of colors were allegedly copied partly by Cofemel in its clothing. The Supreme Court of Portugal was uncertain of the meaning of Article 2 of the Portuguese copyright legislation, and in that regard, the referring court pointed out that that protection clearly included works of applied art, industrial designs, and works of design which constituted an artistic creation in the list of works protected by copyright. It did not specify the level of originality required for such works to be granted the protection. As you know, these two questions ended up in one legal problem, whether Article 2.1 of the InfoSoc Directive on copyright, as interpreted by the court, precluded original designs from being protected by copyright only if they were increased artistic character exceeding what is normally required of other categories of work. Let me start by underlying the division between these two regimes. It is true that in the light of its wording, Article 96 on the regulation of EU regulation on design appears to give member states a wide margin of discretion in the conditions for copyright protection on designs. However, that margin of discretion is given subject to the harmonization of copyright at EU level, which is confirmed by Recital 32 of that regulation, according to which, in the absence of the complete harmonization of copyright law, it is important to establish the principle of cumulative protection under the community design and under copyright law, while leaving member states free to establish the extent of copyright protection and the conditions under such protection is conferred. It is even clear from the explanatory memorandum to the regulation on design that the solution adopted in its Article 96 is intended to be provisional pending the harmonization of copyright. And I proposed to the court, and the court followed, that it was clear that once harmonization has been achieved by means, in the first place, of the InfoSoc Directive, Directive 2001/29, the margin of discretion given to the member states under Article 96 of design regulation was limited by the obligation under that directive. So, in principle, the court said that Article 2.1, as interpreted by the court, precludes industrial designs from being protected by copyright only if they have increased artistic character exceeding what is normally required to other categories of works. The court did not ignore the concerns which were expressed by some governments intervening in the case and some other parties which submitted observations with regarding to potential harmful consequences of overprotection of designs by copyright. Sui generis protection of design, such as that provided by Regulation 6/2002, is well adapted to the specific characteristics of the protected subject matter, that is to say, ordinary, practical and mass-produced goods, which can nevertheless also possess original aesthetic characteristic worthy of protection. That protection is of sufficient duration to allow a return on the investment in developing the design, without, however, placing an excessive restriction on competition. Likewise, the condition under which that protection is conferred based on originality and novelty, as well as the criterion used to determine the act of infringement, the overall visual impression, are adapted to the conditions of the market for that subject matter. However, if it's too easy to obtain for the same subject matter protection by copyright, which is free from any formalities, which applies from the moment of creation of the subject matter and without any requirement of novelty, and the duration of which is virtually limitless in the light of the benefit of the design for its proprietor, there is a risk that the copyright regime would supplant the sui generis regime intended to protect designs. This would have several negative effects: the devaluation of copyright, sought to protect everyday creation, restriction of competition on account of the excessive duration of protection, and even legal uncertainty, in that competitors are not able to predict whether a design whose sui generis protection has expired is also protected by copyright. In my opinion, I explained that this strict application of copyright by national courts could, to a large extent, overcome the disadvantages resulting from the combination of copyright protection with the sui generis protection of designs. It is not a question of extending through copyright the protection conferred on designs up to 70 years after the death of the author, but rather of achieving, with regard to works of applied arts, the specific objectives of copyright using the rules which are specific to it. Copyright and design have different objectives. The latter protects the investment in creating designs from imitating by competitors. In contrast, copyright disregards that protection against competition. Indeed, on the contrary, dialogue, inspiration, and reformulation are inherent in intellectual creation, and copyright is not meant to hinder them. What copyright protects, at least through economic rights, is the possibility of unhindered economic exploitation of work as such. As the court said in a judgment in Cofemel, the concept of work constitutes an autonomous concept of EU law which must be interpreted and applied uniformly, requiring two cumulative conditions to be satisfied. First, that concept entails that there exists an original subject matter in the sense of being the author's own intellectual creation, and second, classification of a work is reserved to the elements that are the expression of such creation. And as regards the latter condition, the Court has stated that the concept of a work that is the subject of InfoSoc directive necessarily entails the existence of the subject matter that is identifiable with sufficient precision and objectivity. That is because, first, the authorities responsible for assuring that the exclusive rights inherent in copyright are protected must be able to identify clearly and precisely the subject matter so protected. So also must third parties against whom the protection claimed by the author of that subject matter may be asserted. And second, they need to ensure that there is no element of subjectivity which is determinal to legal certainty in the process of identifying that subject matter. That means that the latter must have been expressed in an objective manner. As emphasized by the Court, the required precision and objectivity is not attained when an identification is essentially based on sensation which are intrinsically subjective of an individual who perceives the subject matter issue. As you know, the Court decided that the EU legislator opted for a system which is the protection reserved for designs and the protection ensured by copyright are not mutually exclusive. The dispositive of the Court's decision is limited to that statement. May now refer to some comments, because after the decision in Cofemel has been rendered, many commentators said that the judgment has opened a potential can of worms for copyright. The category of artistic art, applied arts, will have to be reassessed, although the change is likely to be welcomed by designers, as it appears to lower the bar for qualification of copyright protection. For many of them, the decision in Cofemel would also impact the requirement of aesthetic effect, which the Court confirmed to be incompatible with the both originality requirement. Whether a work creates an aesthetic effect does not determine whether its creation was an author exercising free and creative choices and implies a subjective assessment. I think that these consequences are not justified in the light of the fact that the Court emphasized different objectives of these two mechanisms of protection. First, although the threshold of originality adopted in copyright is not very high, it is not non-existent. In order to benefit from protection, the effort made by the author must be individual and creative. Outcomes dictated only by the technical result cannot be protected. In that line, it is not necessary for practical objects to display a particular high artistic level in comparison with other categories of works. It is sufficient to apply the creation of the author's own intellectual creation. Any practical object has a visual aspect, the result of the effort made by its designer. However, any visual aspect will not be protected by copyright. And secondly, copyright is based on a distinction between the idea and its expression, with only the expression being protected. With regard to works of applied art, that dichotomy is, in my opinion, likely to mitigate the anti-competitive effects of their protection by copyright. By way of example, I refer to the subject matter at issue in the proceedings in Cofemel case that I think illustrate my point. I think, but it's of course for the national court to establish, that characteristics such as the specific composition based on shapes, colors, words and numbers, the combination of colors, the placement of the pocket, or even the way the jeans are made by assembling the three pieces, which Cofemel is allegedly to have copied, should be analyzed as ideas capable of being expressed differently or even as practical solution and should not be protected by copyright. Moreover, by relying on the innovative and unique, at that time, character of design of G-Star, introduced in 1996, it would appear that G-Star, in this case, is seeking copyright protection for its reputation, and the distinctive character of its goods are normally protected or should be protected by trademark law and not by copyright.